I always say that the small claims court can be kind of like the Wild Wild West. It can be very chaotic, but there are some things that you can do to rise above that and look a little bit better in front of the judge who's the fact finder. And who knows, maybe you will get a better result by doing these things. We're going to talk about that in this video. 4 things to do to help improve your likelihood of winning in small claims court. Stick around. Welcome back to Wedding Industry Law. My name is Rob. I'm an attorney representing wedding industry professionals. And if you're in the unfortunate position of having to sue a client in small claims court or be a defendant in a claim in small claims court, then this video is for you. We're going to be talking about 4 things that you can do ahead of time or at the actual hearing that's going to make you look a little bit better. It's going to make you sound a little bit better. And by doing these things, it's going to very likely add to your credibility in front of the judge. And who knows, you could get a more favorable result from doing these things. So the first one is this. Often, in almost every small claims case, the judge is going to allow or require the parties to give what's called an opening statement, which is you stand up and you jaw for a few minutes about what your problem is, or if you're the defendant, what your defenses are, or whatever. This is your opportunity to frame the case. So the first bit of advice that I have for you is to know your case and put your case into an elevator speech, 1 to 2 minutes tops. And in that, you need to boil down what your case is about and what the real contentions and what the real issues are that are in the case. So in other words, be able to tell the judge what the case is about. Like, the judge doesn't know. This could be a defamation case. It could be a slip and fall case. It could be, I don't know, whatever the case is. But what is the case about? And then understand where you and the other party are at odds. And this requires analysis and real introspection on your part to be able to succinctly get this down to 1 or 2 minutes. It requires you to really understand the other party's perspective. If you understand the other party's perspective, then you can really hone in on where the issues are, because that's really what the judge is going to do. The judge is going to try to sift through everything and get to the heart of the matter. So if you, in your opening statement, can recite where the pertinent facts and where the parties are really at odds with one another, that's going to show that you have a command of the situation and that you have really thought about it. And by doing that, you have credibility, at least at the start. So have your elevator speech ready for opening, rehearse it, practice it. Somebody that knows nothing about you and knows nothing about the case should really come away with that 1 or 2 minutes with a firm understanding of what the case is about and where the points of contentions are. So be ready for that. Have that, to the extent you memorize anything, memorize that and be able to really rattle that off in a succinct and accurate way. So the number 2 thing to help you win your small claim is to let the judge do her job. In most small claims courts, the judge is the fact finder. In other words, the judge is the one that hears the evidence, decides what evidence matters, and then, issues the award, issues the recovery. So as a part of that process, the judge doesn't just simply listen. Sometimes the judge will do their own examinations and ask the parties or the witnesses directly questions. Don't stand in the way of that. Allow that to happen. There is some type of idea that, well, the judge is always asking my witness questions. The judge asks me a lot of questions. The judge must hate me. That's not necessarily true. All the judge wants to do is get to the facts that directly relate to the elements of the claim as quickly as possible and go on to the next case. So just because they're asking you a lot of questions doesn't mean that's bad. So What you want to do is answer directly the judge's question. Do not meander. There should be no, well, what had happened was. You want to stay away from those things. Answer the questions specifically. And then as a corollary to that, don't hide bad facts. If the judge asks you for X and X is bad, don't not give them that. Be like, Your Honor, X, however, Y. That's perfectly okay. But to the greatest extent possible, answer all the questions from the judge directly. No meandering. That's going to build credibility with the judge. The more credible you are, the more likely it is that they're going to see the evidence in your perspective, in your light. So answer directly, answer succinctly. Don't butt in, don't cut off the judge. Let them ask the questions. So the number 3 thing with regard to winning in court or increasing your chances of winning have to do with logistics of your presentation. So number 1 is you don't have to dress in a suit. You don't have to have your best, power suit, your best, your Sunday best. But you don't want to be a bum. You don't want to look like I look right now. If you wear a uniform to work and the case involves your work, wear your uniform. That's perfectly okay. You want to present yourself in a way that shows respect for the court. Tuck in your shirt, no hats typically, these type of things. With regard to how you behave while you're presenting your evidence, while you're addressing the court, you always stand when you address the court, always, unless the judge says that you're allowed to sit. Whenever you say anything to the court, you have to be standing. Typically, you address the court by Your Honor. At a minimum, yes, ma'am, no, ma'am, but typically you would say, Your Honor, X, Y, Z, or Your Honor, no, Your Honor, this is what happened, blah, blah, blah. Although the people's natural tendency is no, ma'am, or no, sir, yes, ma'am. Typically the preferred way to address the court is Your Honor, although, it's okay to say yes, ma'am, or no, ma'am. Definitely not, yeah, These type of things show less respect for the court. The more respect you show for the court, the more credibility you show. And again, as I mentioned, the more credibility you have, the more likely it is the judge is going to see the evidence the way you see the evidence. So being respectful when you speak. The other thing is the court is not necessarily your playground. And although we are programmed by television to see that it's acceptable to walk around the courtroom, it's typically not allowable. You need to ask permission to approach the witness bench or the witness stand. You have to ask permission to move about the courtroom itself. And once granted, you can, but don't think that you can just, well, Your Honor, I've got something to show you, and begin walking up to the judge. The bailiff might smack you down. You say, Your Honor, I have Exhibit A. It's X, Y, and Z. May I approach the bench to give you a copy? Yes or no? This type of thing. In other words, you have to ask for permission if you want to move about. Finally, with regard to logistics, it's never good form to cut anybody off, particularly the judge. We talked about that a little bit earlier, but you never want to cut off the judge. Let the judge say what the judge is going to say, and then you say your thing. Never cut the judge off. But also never cut the other party off. Even though the party might be lying, even though the party might not be saying, the full truth as you see it, they are allowed to do that and say their piece. Then you say, Your Honor, if I may, opposing party said X, this is not true. Here's the truth, or whatever. But when you interject, it's a problem for a couple of reasons. Number one, the judge wants to get their perspective of what happened, and you're preventing them from doing that. Even if it's a lie, even if it's not correct, they still want to understand where that part is coming from. So when you do that, you're keeping the judge from getting their perspective. And number two, oftentimes when we're cutting someone off, it's because we don't want that information shared, and that makes you look bad. So we don't want that. So allow everyone to speak their turn. And then once that's completed, then you come in and with the opportunity to control the damage or say the truth. And finally, number 4 is be organized with the evidence that you want the court to see. And what I mean by that is you don't want to be shuffling for things. You don't want to, take your purse up on the table and you're digging through it to find some document that you need. If you're going to show a document, if you're going to show a piece of paper, it needs to be at your fingertips. You don't want to have to spend time like, well, Your Honor, I left it in my car. It needs to be right there. Your Honor, here's Exhibit 1, blah, blah, blah. By that same token, to the extent that you want to show the court anything, and it's a paper, you typically want to bring copies, okay? Because typically the court is going to say, has the defendant ever seen that? And you're going to go yes or no. And if it's no, the judge is going to go, you need to show it to him. And so here's your copy, defendant, and judge, here's your copy. So having 3 copies, yourself, for the other party, and for the judge, usually makes you look really good, increases your credibility, and that's the name of the game. The other thing is that if it's a picture on your phone or a text on your phone, typically what you want to do is get this, put on another, actually get it printed out if you possibly can. I've seen sometimes, the judge might say, well, let me see your phone. They'll look at it, but you want to be able to print something off so you can maybe blow it up. The judge can see it better, these type of things. So to the extent that it's on your phone, get it off your phone, but have it ready just in case, the judge wants to see it. But at the end of the day, you don't want to be shuffling through documents. Things need to be ready. If you've got a timeline, you're going to put your timeline out on this part of the desk, have your exhibits on this part of the desk, have your cheat sheet over here, but you don't want to waste the court's time. So be organized as much as you possibly can, increases that credibility. So that is 4 things that are going to increase the likelihood of you winning your claim, or at least being a good advocate for yourself in small claims court. So if you enjoyed the content of this video, please be sure to like and subscribe. If you've ever been in small claims court, leave a comment down below. Let me know how it went. How was your experience? Did you win? Did you lose? Let's talk about it. But new videos just like this at Wedding Industry Law every Monday. They drop. Hope you had a great time as I did. And with that, folks, we'll see you next time.